Hello everyone, it's Dylan here from websitedesign.co.za. Today's video is going to be a little bit more serious. We're going to chat about all the legal things behind your website and your hosting. So let's get started. Is your website compliant? When you commission a new website, your focus is naturally on the aesthetics and how well it represents your business. Your focus is on the layout and the branding and the user experience. However, operating a website in South Africa means entering a strictly regulated environment. We effectively operate under what is often called the Twin Peaks of regulation: the Electronic Communications and Transaction Act and the Consumer Protection Act. These laws ensure that you actually own the digital assets you are paying for and protecting your business from liability. Electronic agreements. When a user interacts with your website, whether they're buying a product or signing up for a newsletter, they're entering into a contract. ECTA facilitates this by giving data messages legal force, meaning a digital agreement is just as binding as paper one. There are generally two types of agreements you will encounter. The first one is a checkbox agreement, where the user must click "I agree" to the terms before proceeding. The second one is the fine print agreement, where terms are hyperlinked at the bottom of a page. For these to be enforceable in court, you need a solid evidentiary trail. Your website's backend needs to design its checkout flows to capture and log the moment of assent. This means recording the specific timestamp, the IP address, and the exact version of the terms the user agreed to. Without this technical log, it is very difficult to prove that the user actually agreed to your terms. Is your domain registered in your name? A domain is a valuable piece of intellectual property. However, a common bad habit in the web design industry involves some businesses and freelancers registering the client's domain on their own to retain leverage. This practice is a violation of the policies set by the Central Registry, ZACR. The relationship between the registrar and the registry requires that the data submitted must be accurate and belong to the legitimate beneficiary. As the client, you are the beneficiary. If the domain name is registered in the agency's name, they legally hold your keys. If a dispute arises, they could effectively hold your domain hostage. Well, ZACR now redacts personal information from the public WHOIS database to protect privacy. The ownership data is still accessible to the registry and the law enforcement. You must always verify that you are listed as the registrant. Private information and cookies. If your website collects any data like names, emails, or even browsing habits via cookies, you fall under the Protection of Personal Information Act. Your website can collect cookies without knowledge via a default setting in your CMS system. It is important to make yourself aware of these settings and what information is actually being collected. In this instance, you are the responsible party because you are the one deciding why the data is being collected. Your web hosting company or design agency is the operator. Crucially, Section 21 of the POPI Act mandates that there must be a written contract between you and the operator. This contract must explicitly state that they have securities measurements in place to protect your data. The POPI Act also changes how you handle digital marketing. Section 69 prohibits unsolicited electronic communications, such as newsletters, unless the user has consented or it's already a customer. The law requires the consent to be express. This means the old tactic of having a pre-ticked checkbox that says "sign me up for news" is no longer compliant. You must use an opt-in mechanism where the user actively clicks the box themselves to join your list. Do I own the content on my website? This is perhaps the most critical section for any business owner to understand, and the legal framework is prescribed in the Copyright Act of 1978 and the Trademarks of 1993. The most frequent and costly legal trap is infringement, using content you don't have the legal right to use. Instances can occur where a freelancer or agency may have used unlicensed assets on your site, even without realizing the full legal implication. Many people assume that any content on the internet is free, but every single image, typeface, block, or marketing copy or video is copyrighted. The financial liability usually falls under the website owner and not the website designer. To protect yourself, you must request proof of licensing for the assets used. You may, however, use free image and asset resources that clearly state that the stock media and assets can be used for commercial use and can be modified. This is how you guard yourself against infringement at all costs, including avoiding replication of competitors' logos or content. The second major risk is that even after paying thousands, you may not actually own your website's engine. The legal default is often the designer agency retains the copyright to the code. You might only end up with a license to use the site, not ownership of the source code. This means you cannot easily move, sell, or modify the code without the original creator's permission. You need to protect your IP by making ownership explicit. The service agreement must clearly define whether copyright is transferred or retained. You must ensure ownership of the creative work is clearly defined in the service agreement. Security and incident reporting. Website security is bigger than just a technical problem. Section 19 of the POPI Act requires you to implement appropriate technical measurements to prevent data theft. This means using an SSL certificate and reliable and secure hosting company. If your website's hacked, you need to perform a few actions. You have to notify the information regulator and the affected customers immediately. Additionally, Section 54 of the Cybercrimes Act imposes a duty on electronic communication service providers to report cybercrimes to the South African Police Service within 72 hours. While this specific section has faced delays in commencement, the obligation to preserve evidence for police investigation is critical. Here's the conclusion. Website compliance can be a lot to digest. That's where websitedesign.co comes into play. You probably started with your business with the focus on selling product or a service and not to worry about Section 43 of some act you've never heard of. But ignoring these laws isn't an option anymore. At websitedesign.co.za, we ensure that your forms don't break privacy laws, your features are legally correct, and your hosting setup is secure. You handle the business, we'll handle the compliance. If you are unsure about your current site, or if you just want to get right from the start, let's have a chat at action@websitedesign.co.za.